Hello. This video reviews what was done in the third tutorial. So we started off by looking at ETMA 01. Two questions that you faced. The first one was about sources of English law, and what I had been looking for was for you to describe, explain, very importantly give examples, and then marshal the arguments into a conclusion. So structure, obviously very important there. In the second question, which was a problem question which allowed you to discuss the differences between criminal and civil law, again I wanted you to get over the key differences, but an important point to make is the importance of structure. There are two ways of answering problem questions. One is to identify what the subject matter is, in this case the differences between criminal and civil, and write an essay about that, and at the end bring in a few references to the question. The better way is to structure your answer to the question, and as you explain, as if you were talking or writing for an intelligent non-specialist, use the question as the structure for answering. So go through each point and explain. And that difference in structure can make a whole lot of difference, particularly as you get further on in the courses. If you take the approach of writing a general essay on the subject, even with the exact same information, that structure is going to get you a pass, certainly. But the higher marks, where you actually apply to the problems of the question, will give you, as I say, much higher marks. So for both of those questions, the structure is important, as well as the explaining, the describing, the giving examples to illustrate your arguments. We then had a look at two key issues which, although not relevant for these TMAs, could well be relevant when you come to face examinations at the end of the summer. The first is the question of the role of lay people in the justice system, magistrates and juries. They do play an important role, and again there's a wonderful option for putting questions to invite you to discuss the advantages and the disadvantages of using non-legally qualified people in such an important role. So do review that subject. It's dealt with in the manual. The other issue, of course, is the legal professionals, the barristers, the solicitors, the judges, and the courts structure in which they operate. So again, useful area to review in your reading. We then moved on to a taster for the next topic, which is constitutional law. And you'll come across a number of points, but the ones I would highlight, first of all, the language that we use. We do talk quite accurately of the British Constitution. Now, of course, we don't have a constitution in the sense that the Americans or the French or almost every other country in the world has, where you have one document which purports to have all the constitutional rules. Actually, in practice, it's not quite that simple. The Constitution, like the American Constitution, is a very small document, but one of the books behind me, which is a really thick book, covers all the cases, the academic writings, which American lawyers have to use when applying that Constitution. But we don't have a single document that we can look at which gives the structure. We will find our Constitution in a number of places. So there are statutes. There is a statute, for example, the Act of Settlement, which defines who the monarch can be. There are statutes which define who can sit in the various parts of Parliament. So the House of Commons Disqualification Act, which states that judges can't sit in the House of Commons and members of the executive can't sit. Members of the lower executive, as we'll see, we have a system of accountability where the higher levels of the executive are also represented in Parliament and accountable to Parliament. So There are statutes, there are case law, not as much as from some of the other subjects that you're going to look on. I mean, later on you'll look at contract law and tort law, and they're areas where case law plays a very important part. Not quite as important constitutional law, but you will see that there are some constitutional cases. And then there are conventions. Difficult concept to grasp initially, because the word convention means different things in different contexts. We talk about a convention to write a constitution in the sense of a meeting. When we're talking about conventions as a source of English law, we're talking about non-legally enforceable rules, i.e. rules that you can't go to court and say, they've broken this convention, we want a court order requiring them to do it, because the courts will say no. But which the political actors, or perhaps a better term would be the constitutional actors, because we'd include the Queen in this, regard as binding. So, for example, there is a convention that all bills that have passed both the House of Commons and the House of Lords will be signed into law by the Queen. If she fails to do so, she couldn't be sued over it. But if you were to ask her, she'd say, no, I don't have any choice. Convention, one in this case that's over 300 years old, requires that I sign in those circumstances. So conventions are another source. Two doctrines you'll come across. The first is separation of powers. It goes back some considerable time, in fact, to the ancient Greeks, where analysing what government does, they concluded that there were three functions of government: making law, carrying it out, and the judging function, which is partly interpreting what the law is, and secondly applying it where there's a dispute. Montesquieu, in later days, applies this and argues that separation of powers isn't just a way of analysing the functions of government, but is actually central to avoiding tyranny. He says if you've got all these powers to make law, to carry it out and to judge in the hands of the same person, tyranny will inevitably follow. So he argued, and he used England as an example, where the king couldn't do everything. This was, of course, after the Civil War and the constitutional revolutions that we had in the 17th century. But of course the Americans, when they're actually able to sit down and design a constitution, say, right, we will have this separation of powers. If you're in one branch, the making law branch, the legislature, the legislative power, then you can't be in the executive power. So when Barack Obama became president, he wanted in his cabinet some colleagues who'd been senators and members of the House of Representatives. They had to give up their seats to serve in the executive. Members of the executive and the legislature, Congress, cannot sit as judges. Now in the UK we have a partial separation of powers. Central to our system, of course, is the idea of ministerial accountability, that the Prime Minister, the members of Cabinet and the other ministers who head the executive are accountable to Parliament and by convention sit either in the House of Commons or the House of Lords. But there is separation of power with the judiciary. You couldn't be a member of Parliament and remain a judge. And now, after the Constitutional Reform Act of 2005, members of the Supreme Court are no longer able to sit in the House of Lords sitting as a legislative body. So, separation of powers, there to control the use of power. Parliamentary sovereignty, concept that is associated with a writer called Dicey, and he's useful to look at. Whether you agree with what he's saying or not, it's a useful framework to approach the topic. So, what Dicey says is, firstly, Parliament can pass any law it wants. He was contrasting the situation in the United States, where the Supreme Court can strike down an act of Congress because it's unconstitutional. There are no legal limits on what Parliament can pass. The second meaning is that no parliament is bound by its predecessors. Each parliament coming in can make new law. You'll come across the term entrenchment, which is about measures to make it either impossible or more difficult to change the law, and things like requiring special majorities in both houses or requiring a referendum. In this country, we don't have entrenchment, and that's what Dicey was saying, that any new parliament comes in, can change the law, can even change the constitution by an ordinary act of parliament passed in the ordinary way. And the third meaning was that no court could question what Parliament had done, and that's derived from the Bill of Rights, but has come to mean that courts can't overturn what Parliament's done. Useful framework, so you don't have to agree with it, and now, of course, it's common to ask whether our membership of the European Union and also our involvement in the European Convention of Human Rights, whether that contradicts the doctrine of parliamentary sovereignty. As I say, that framework from Dicey is a useful way of describing and then challenging the claims of parliamentary sovereignty. So finally on to ETMA 2. Two questions again, the first on statutory interpretation, the second on the use of language. Two things I would stress. Firstly, do look at that assessment criteria. If in your mind the question is, why have I got a mark less than I expected it to be, the answer is in the assessment criteria, because those are the criteria that I work with. So do make sure that you're fully happy with understanding what those criteria are and what is the difference between the different bands. The second is the importance of the advice on answering the questions. So on to statutory interpretation. This question involves you describing and explaining the rules. So I want you to define what those rules are, give examples. And the second part is explaining and critically evaluating the views expressed in the quotation. The people who've put forward this quotation are suggesting actually that it's quite dangerous. Well, are they going overboard there? Or is there an important point that they're making? And of course, are these rules in the sense that we would normally understand them? So, statutory interpretation. Second one illustrates something that's true of law in many ways, is that the same words can mean different things in different contexts. So here we've got common law, civil law and equity. Civil law, of course, you dealt with in ETMA 1 when you were contrasting civil law as opposed to criminal law. This time it's the use of the word is different. We're talking about civil law systems, and we associate those with continental Europe, and common law system that is the Anglo-Saxon system. And what I'm looking for is for you to highlight the distinguishing features of each of them. So what's a common law system? What's a civil law system? Explain what makes them different. Then common law and equity. Different context, different meanings for the term common law, but where you're contrasting the two. Again, what are the distinguishing features of common law as opposed to equity? And of course this one requires quite a bit of historical detail. Anyway, hope you found this useful, and look forward to receiving your TMAs.